Expired. I call Claire Curran.
Thank you, Mr Speaker. Mr Speaker, as you've heard tonight, Labor is opposing this bill, and if it does get to the Select Committee, then I'm sure we're going to have an interesting time discussing the various legal cases for and against on this particular issue, because this bill actually amends legislation that Labor pioneered in 2002, which removed impediments to e-commerce, which brought New Zealand into line with many other of the developed countries in the world. And at that time, it was part of Labor's digital strategy. And remember, this is 10 years ago, Mr Speaker, 10 years ago, which was when there was a lot of work being done by the previous Labor government to introduce a digital strategy. This work amends that, and what we say tonight is that this should be a government bill. It shouldn't be a private member's bill, it should be a government bill, and that there is an inherent contradiction in it, which is why we are opposing it tonight. And at the heart of it is the issue that there's a fundamental difference between snail mail and email. And no doubt if the bill does pass tonight, then that will be teased out. As we have said, we are describing this bill as spam, and that is not meant to be a slur on the member who has done the work on this bill, but it is actually a criticism of the fact that there are many other important issues that could be being debated in this House, and if there needs to be a law change in this area, then the government should have brought this bill. The Minister of Communications and IT should have actually done the work and provided the advice that would have brought this law change to the House. So what I'd like to say about this bill is that there's been discussion over the years about whether the postal acceptance bill should be extended to online scenarios, but the prevailing view is that it should not. The issue was briefly considered in a 2009 Australian Federal Court case, which the judge concluded in the effect that the postal acceptance rule should not apply to acceptance by email. Now, we have discussed this issue in other bills, if the members on the opposite side of the House remember in the Select Committee, if they were paying attention, and that is around what happens when an email arrives in your inbox, and it is the person whose inbox it is liable for the contents of that email if they don't know it's there, if they haven't looked at it, if they haven't opened it. And that is the question, because there's a great big difference between when you send a letter to somebody by snail mail and when it arrives in a physical letterbox than when you send an electronic email to somebody and it goes within seconds. There is some considerable issues there to be determined. Case law suggests that based on the Brinkebon case, which was a leading decision of the House of Lords on the formation of a contract using telecommunication, and together with Section 11 of the Electronic Transactions case law, that the bill means that the contract is formed when an email arrives rather than when it is read. But this is not clear in the bill itself. So perhaps if Mr Goldsmith would like to clarify to the House what he actually intends the bill to do, then we would be able to make a more informed decision about this bill. Labor is pushing ahead with a comprehensive digital strategy in our development of policy, Mr Speaker, which involves looking at the whole of the digital environment. A bill such as this, as I said, should have come before this House as a government bill if the law needed to be changed, and that should have been on the advice of officials. There could have been many other issues that we could have been discussing in this House tonight of great moment in the digital environment. And, certainly we do give congratulations to National for moving beyond the quills and typewriters and acknowledging the existence of the digital age, but there certainly are other major issues that could have been discussed tonight.
I call Kanwaljit Singh Bakshi.
Thank you, Mr. Speaker. It's my pleasure to stand in support of first reading of electronic transaction